Well, back home, the biggest issue in the world's biggest democracy may be settled soon. India's apex court today refused to refer to a larger constitutional bench in 1994 ruling on whether a mosque is integral to Islam, thereby resuming daily hearings in the Ayodhya land dispute case. The hearings will begin on October 29th in the matter, which has been pending in the top court for the last 7 years. This is especially significant since India is heading for elections next year. As per the verdict, the Ismail Faruqi case of 1994 in the Ayodhya case. However, Justice Nazir dissented, saying what constitutes essential practice of religion needs to be reviewed by a larger bench. In 1994, the Supreme Court ruled in the Ismail Faruqi verdict that the mosque is not essential to Islam, as namaz or prayers could be offered anywhere in the open. Earlier, Muslim groups had argued that the judgment will have a direct bearing on the Ram Temple Babri Mosque case.
The essence of the court's judgment is that the observations in the Faruqi case were in the context of acquisition of properties and could not be construed to say that if there is a particular place of special significance, that will not be treated as essential to the religious practice. They have also said that issues which are arising in the title suit are not directly impacted by the observations in Faruqi case. Therefore, the matter doesn't have to go either to a larger bench, and the other appeals have been directed to be listed on the 29th October for hearing.
Judgment of the majority is flawed. It reads down the status of a mosque by saying all this was in the context of acquisition. The answer is no. In fact, the court said this wasn't even an acquisition statute. This particular sentence was torn out of everything else and said mosque is not an essential practice. The Supreme Court has never done this without examining the issue.